Chinese President Xi Jinping's visit to the Philippines is historic, not only because it's the first state visit of a Chinese leader to Manila in 13 years, but also because it could pave the way for a possible joint exploration in the disputed waters. And this is exciting a lot of investors. Just look at the share price movement of companies like PXP Energy, which has a long-standing proposal to jointly explore the recto bank with China's CNOOC. But before we get into the economic implications of a possible deal, will a joint development even be legal? Hello, I'm Mikey Orata and you're watching Square Off Season 16, The Firm Debates. China Telecom winning the Philippine telco race with its local partner, Dennis Uy, and a commitment to conclude a code of conduct in the disputed South China Sea within 3 years. All that bookended the visit of Chinese leader Xi Jinping to Manila earlier this month. The latter in particular stirring excitement in the oil and gas industry with the prospect of a joint exploration deal shining even brighter.
China is also ready to further discuss with the Philippines about the joint development of oil and gas in the South China Sea to solve differences and pursue joint development.
The output, a memorandum of understanding between the two states that provides a framework for any possible future cooperation. The reactions, however, have been mixed.
Right now, it doesn't actually form the basis of any action, any specific project. No, it's just a basis to continue to negotiate.
Pero ngayon may decision na, bakit pa tayo papayag na parang kinikilala natin ang posisyon ng China when in fact nanalo tayo? Parang hindi ata tama yon. Tayo ang panalo doon. Bakit hasta tayong talo?
Critics worry that President Duterte, who's been very open about a China pivot, may be selling out the country in exchange for soft loans.
Hindi tayo patatawarin ng mga susunod na henerasyon kung malaman nila pagdating ng panahon na nagkaroon ng gobyerno na ipinamigay yung ating desisyon na naipanalo.
Hindi nakabayad yung Sri Lanka sa pinautang ng China. So ang napuwersa yung gobyerno na kumbaga ay isuko yung kanyang isang malawak na port, yung tinatawag na Port Hambantota, sa isang 99 years na lease sa China bilang pambayad.
Amid all of this, Malacanang insists that no sovereignty is or ever will be given up. But will the joint exploration and development of the West Philippine Sea between the Philippines and China be unconstitutional? Arguing for the affirmative side is the University of San Carlos. From the Queen City of the South, Cebu, the next generation lawyers from the University of San Carlos.
Debating for me, it's all about discourse. It's not about imposing your will over the opponent. It's all about, at the end of the day, it's all about learning together in the certain topic that we would like to expound. There's nothing more I can say about my teammates. They're all confident, they're all excellent and well prepared for the future matches that we will be facing.
Debating is a process of learning the issues and applying them to everyday situations. As a debater, you are the person who first and foremost learns and gets to know and gets to the core of these issues.
Debating is both a sport and also a type of discourse. So there's mental sparring involved, there's a lot of skill involved in it, but it also, the goal of debate is to really bring forth a message to the public that there are certain issues that we need to discuss and bring to a specific level.
Team University of San Carlos, driven, dynamic, disciplined. And taking on the negative side is the University of the Philippines. Imbued with honor and excellence, the next generation lawyers from the University of the Philippines.
Debating for me is a way to understand different issues, not just from your own bubble, but also to understand issues from different perspectives. And unlike the usual kind of discourse that is plaguing the internet right now, debate is more structured, and therefore you can't really have personal attacks.
Debating for me is a big challenge, as I think of myself as not a very eloquent speaker, so debating would be a way for me to improve my speaking skills, as well as I think it's training ground for a future practice of law, especially if I choose the path of litigation.
I also debated in undergrad, so it was a way of learning more about the world and the views of different people and how we can engage with each other.
Team University of the Philippines. Sharp, fierce, diverse. And now let's meet our distinguished judges. First off, we have attorney Antonio Miguel Lu, a senior associate at the VNA law firm. Next, we have attorney Ferdinand Casis. He's a professor at the Ateneo Law School. He's also a lecturer at the Philippine Judicial Academy and the Center for Global Best Practices. And presiding as our chief adjudicator is Judge Maria Teresa Camanong from the Regional Trial Court, Branch 9 of Malaybalay City. We're using a modified Oregon Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition: let it be resolved that a joint exploration and development of the West Philippine Sea between the Philippines and China is unconstitutional. First up for the affirmative side is Ken. You've got 4 minutes to tell us why jointly exploring and developing areas in the disputed waters is unconstitutional.
Your Honors, ladies and gentlemen, good evening. On the line today is Article 12, Section 2 of the 1987 Constitution, which provides that all natural resources are owned by the state. Its exploration, development, and utilization shall be under the full control and supervision of the state. The Constitution provides, Your Honors, that in the exploration, development, and utilization of these resources, a third-party corporation may participate in at least 2 ways. First, the state may enter into co-production, joint venture, or production sharing agreement with a domestic corporation, at least 60% of whose capital is owned by Filipino citizens. Second, Your Honors, the President may enter into an agreement with a foreign-owned corporation, but only with respect to technical or financial assistance. Thus, Article 12 of the Constitution underscores 2 things. First, it makes a distinction between a joint venture for exploration and development, which is the topic of tonight's debate, and a financial or technical assistance agreement. Second, it specifies the kind of corporation qualified to undertake each scheme. Tonight's proposition, Your Honors, involves joint exploration and development between Philippines and China. We submit, Your Honors, that joint exploration and development partakes the nature of a joint venture, which may only be participated by a domestic corporation, at least 60% of whose capital is owned by the Filipino citizens. Yes, Your Honor, please.
Are you saying that the joint exploration is not financial or technical assistance?
Your Honors, if that is the case, Your Honors, then this debate is half won. In this case, Your Honors, the party's choice of the word joint is deliberate with full knowledge of its legal consequences. This is further supported by the previous, contemporaneous, and subsequent conduct of the parties leading to the draft framework. This leads me to my next argument, Your Honors. The negative side may argue that joint exploration and development with China, which is the topic of tonight's debate, is constitutional, primarily because an FTAA is allowed by the Constitution. Your Honors, for emphasis, joint exploration and development is not FTAA, and FTAA is not joint exploration and development. In joint venture, Your Honors, as held in Kilosbayan versus Gingona, it presupposes mutual right of control, community of interest, and beneficial ownership. This leads me, Your Honors, to the further evidence between the Memorandum of Understanding and the Joint Maritime Agreement for Oil and Gas Exploration, which this is the proposal between Philippines and China, which provides for provisions on mutual respect, mutual benefit, and outcome sharing. On the other hand, Your Honors, a joint venture is an antithesis of an FTAA. This has been made clear already in the case of Labugal Belaan versus Ramos, wherein the Supreme Court held that while an contractor is paid by the contracting state only for its technical services, unlike the partner in a joint venture, Your Honors, an FTAA holder acquires no beneficial ownership and no right of control. Therefore, this leads us to conclude that a joint exploration and development, which is the topic of tonight's debate, is not of mere financial or technical assistance, which a foreign-owned corporation may only participate. In conclusion, Your Honors, when we speak of joint exploration and development, the Constitution cannot be any clearer. The state may only do so with a corporation, a domestic corporation at that, at least 60% of which is owned by Filipino citizens. Clearly, not a foreign-owned corporation, or worse, not a foreign state as that of China. Thank you for your time and indulgence, Your Honors. Good evening.
2 minutes for the cross-examination.
Good day, Council. I hope you're having a good one.
Of course, good evening.
So, you mentioned Section 2, Article 12 of the Constitution, correct?
Precisely, I
Wherein
mentioned
you cited that the exploration, development, and utilization of natural resources shall be under the full control and supervision of the state, correct?
That's what I said, Ms. Speaker.
And
Yes.
it also provides for different options for the state to directly undertake such activities into co-production, joint venture,
Yes,
etc.
those were the
Yes.
three major schemes, Madam Speaker.
Yes, and so aside from the arrangements wherein these agreements may be with either Filipino corporations or associations with 60-40
Precisely.
capital
Joint venture.
arrangements. Okay. Now, so for the Constitution under Article 12, Section 2, Paragraph 4 states that for large-scale exploration, development, and utilization of minerals, petroleum, and other mineral oils, the President may enter into agreements with foreign-owned corporations involving either technical or financial assistance according to the general terms and conditions provided by law, correct?
That is correct, Madam
And
Speaker.
yes, this doctrine is reinforced in the case of Labugal Belaan, which you just cited.
Because
correct?
FTAA is involved in Labugal Belaan.
Yes.
Precisely.
So, are you familiar with PD 87?
Yes.
Yes. So, PD 87 provides the terms and conditions contemplated in the Constitution, correct?
Likewise, in Philippine Mining Act.
Yes. So, basically, you were saying that FTAAs are constitutional, correct?
FTAAs are constitutional because the contractor merely extends technical or financial assistance, which is not joint exploration and development.
So, you were limiting the definition of joint exploration and development to joint
The
ventures?
party's use of the word joint is deliberate with
okay,
full
thank you,
knowledge of its
Counsel.
legal
Are
consequences.
you familiar
They could have
with-
provided service contract,
Are you
Madam
familiar
Speaker.
with the Memorandum of Understanding?
just mentioned that, Madam Speaker.
Yes. So under the Memorandum of Understanding, the Joint Steering Committee, if the Joint Steering Committee, for example, agrees to form an FTAA, that will be constitutional.
That is
correct?
constitutional with the
Okay,
foreign-owned
thank you.
corporation.
Amy, you have 4 minutes to advance your argument on why a joint exploration deal between Manila and Beijing to explore and develop areas in the disputed waters is legal.
Beautiful people of the audience, Your Honors, a pleasant day to all. The affirmative's position seems to be that it is illegal or unconstitutional to enter into any and all joint exploration and development arrangements with China in the West Philippine Sea. For the purpose of this debate, however, joint exploration and development should not be seen merely as an arrangement between two countries or two states to agree to
explore or exploit an area's resources together. This view is not only oversimplistic, this is problematic in light of the new conditions that we are facing right now. In reality, the joint development and exploration under scrutiny today is of a different nature, as we can see from the recently signed Memorandum of Understanding or MOU between the Philippines and China. Unlike the usual joint development agreements, this is not being entered into because there is an ongoing territorial dispute. Neither does the MOU contain any claims on the rights and obligations of the parties involved. Because of this MOU, the government can be more flexible in reaching an agreement with China under different development and exploration regimes, such as financial and technical assistance agreements or FTAAs, as well as other types of service contracts. Under this framework, we in the negative side submit that such endeavors to explore and develop the resources in the West Philippine Sea with China are not unconstitutional for two reasons. First, this will provide Filipino citizens the opportunity to use and enjoy the resources in our exclusive economic zones or EEZs. This will fulfill the policy behind Article 12, Section 2 of the Constitution regarding the exploration, development, and utilization of natural resources. And as elucidated in the Labugal-Belaan case, this provision is meant to allow Filipinos to benefit from these resources. The MOU with China has not even yet determined which specific maritime areas in the Philippines will be explored and developed. And given the wide breadth of options that is provided by the MOU as to how to go about this joint exploration and development, it is safe to presume that the government will pursue the constitutional route. The presumption of constitutionality thus applies, and there is no incentive for the parties, by virtue of this MOU, to enter into agreements that will be that will be patently unconstitutional. And it would be pointless to enter in agreements that will be annulled when it is subjected to the scrutiny of the courts. It would just be impractical for them. So under a service contract model, we will not be ceding profits to the Chinese government. Rather, they will be shared with possibly Chinese entities who are acting as contractors or maybe investors subject to limitations prescribed by law. Bless Your Honor.
Counsel, wouldn't the Filipinos benefit more if only the Philippines will explore and develop?
In a perfect world, thank you for your question, Counsel. In a perfect world, yes. However, the reason why this provision for financial and technical assistance agreements are there is because we may not have all the means and technology in order to explore and develop our resources. And the financial and technical assistance agreement will kick in for them to just provide us with the technology and the resources and the initial resources so that we can develop them faster. So our second reason for the constitutionality of these joint development and exploration agreements is because it does not actually compromise our territorial claims. In fact, it would even reinforce our territorial claims. By virtue of this MOU, we are putting China in a position where it has to respect our economic rights over our maritime territories in the West Philippine Sea. Moreover, Section 4 of the MOU states that the Memorandum of Understanding and all discussions, negotiations, and activities of two governments or their authorized representatives under or pursuant to this Memorandum of Understanding will be without prejudice to the legal positions of both governments. Thank you.
2 minutes for the cross-examination.
Madam Speaker, good evening again.
Good evening.
You have shared a while ago that China will not receive any share in the exploration.
I did not say that.
Well, you just mentioned that.
I did not say
Madam
that.
Speaker, you've quoted...
Under an FTA,
Madam
they
Speaker,
will
it's my
receive a
time.
share.
Disrespect my time. I'm the
Sure.
one asking the question. You have mentioned the Memorandum of Understanding, right?
Yes.
And it provides for provisions on mutual benefit, mutual
No.
respect, and outcome sharing. We have here...
Those are general provisions, not exactly.
We have here, Counsel, the actual copy of the Memorandum of
Yes.
Understanding. And you have also read, I presume that you have read, the Joint Maritime Agreement for Oil and Gas Exploration just concluded this November. Agree? You have read that? This also provides for mutual benefit, outcome sharing, and mutual respect. Agree?
Yes, and what is your question? What is your point?
You will find the relevance, Madam Speaker. In 2016 and 2017, there is a joint statement between the Philippines and China regarding joint exploration
But are
and
those
development.
still effective because
Madam
of this
Speaker,
new MOU?
Madam Speaker, this shows the intention of these states to enter into joint exploration and development.
Not
Would you agree with
necessarily.
me? Would you agree with me that mutual benefit, mutual respect, and outcome sharing, which is the principle of the MOU, the Joint maritime agreement between Philippines
it
and
does
China.
not
Madam Speaker,
commit to anything.
let me finish my question. These legal characteristics pertain to joint venture. Agree?
Not
Are
necessarily.
you familiar with the Malampaya project?
Yes, of course.
Is it not that there's no issue as to whether it is joint exploration and development because between Philippines and Shell, the contract is merely denominated as service contract. Agree?
Yes, and
Service
it will
contract
still be of
presupposes
mutual benefit
FTAA.
because if you
But
have a
that-
service
Madam
contract, they will be paid
I've heard
service
enough, Madam
incentive.
Speaker. It's okay.
Okay.
Would you agree with me that joint exploration and development, which is joint venture, may
No.
only be participated by domestic corporation? Agree?
Joint
That is provided
no.
by the Constitution. And China,
And then
as a state, Madam
Article
Speaker,
4 provides
it's
for
okay,
an
it's okay.
exception. Paragraph
No
4
further
provides for an
questions, Your Honor.
exception.
Let's now hear from the second affirmative speaker, Eunice. You've got 4 minutes to tell us why it would be beneficial to deem a China-Philippines joint exploration of the West Philippine Sea as unconstitutional.
Your Honors, ladies and gentlemen, good evening. The negative side earlier argued that this JED is a different nature, citing that they can enter into service contracts to make this agreement constitutional. Your Honors, clearly the negative side has missed the spirit of this debate. Lest we be misconstrued, the affirmative side is not against FTAAs. Your Honors, this negotiation, or rather this agreement, does not partake of the nature of an FTAA. The intent of the parties is clear. Consistently, from the November 2016 and from the October 2017 joint statements between the Philippines and China carried over into the draft framework on joint oil and gas exploration, the parties clearly stipulated, and I quote, mutual respect, mutual benefit, and outcome sharing. Your Honors, these elements are not present in an FTAA, where in the case of RBAC versus Sanitary Wares Manufacturing Corporation, the Supreme Court expressly pronounced, Your Honors, that financial and technical assistance does not grant beneficial ownership to foreign corporations, Your Honors. Thus, clearly, the intent of the Constitution in prescribing limitations in section 2 of Article 12 is to limit the exercise of exploration, development, and utilizations only to FTAAs, only to foreign-owned corporations, which is not the case here, Your Excellencies. Clearly, the negative side, by arguing that this joint exploration and development is not a joint venture, has only, Your Honors, highlighted the fact that there are in fact agreements or engagements which are not regulated by the Constitution. Your Honors, this argument cannot stand. In effect, they are arguing that the provisions under Article 12 are not exclusive. However, Your Honors, the provisions under Article 12 have to be construed strictly, as natural resources are matters of vital public interest, calling for a strict interpretation of the law, as can be gleaned from page 354 of Volume 3 of the Records of the Constitutional Commission. Thus, Your Honors, the affirmative side submits that this joint exploration and development between the Philippines and China in the West Philippine Sea must be declared unconstitutional for at least two beneficial results. First, full control over our natural resources allows us to cope with the ever-booming population. And secondly, declaring this act unconstitutional would be to establish permanent sovereignty over our natural resources and strengthen the arbitral award for which we have won and earned the respect of the community of nations. On our first point, Your Honors, the drafters of the Constitution themselves have acknowledged that we are a resource-rich but populous nation where there is a constant demand and competition for resources. In fact, to cite record number 56 of the Constitutional Commission, Your Honors, the reference to the national product being for the benefit of the Filipino people is to ensure that any effort towards national development must focus on the needs of the local population and not foreign consumers. Yes, Your Honor.
Are you saying, Ms. Speaker, that if we enter into this joint exploration, we're already waiving our sovereignty?
Your Honors,
is that what is written in the MOU?
Your Honors, based on the MOU, the perception or the intent of the parties is on a joint venture, which can only be undertaken if it is with a foreign, or rather a Filipino corporation. But what is involved in this case, Your Honors, is there is an MOU undertaken with a state. Therefore, it does not follow what is legally contemplated in the Constitution. Thank you, and good evening.
2 minutes for the cross-examination.
Maayong hapon, Eunice.
Good afternoon.
Okay. So you mentioned that you're working from the draft of the draft framework. Yes, correct?
Yes, we mentioned the draft.
But a few days ago, you are also aware that there have been a memorandum of understanding released between Philippines and China, correct?
Yes, and still
in the
provides for
memorandum-
mutual
yes,
benefit
thank you,
mutual
Eunice.
and
No,
outcome sharing.
As I will correct you, there is no outcome sharing under the memorandum of understanding.
Because
We
that is only the establishment
yes, thank
of
you,
a
Eunice.
joint
Thank you,
committee.
Eunice, for your opinion. Okay, under the memorandum of understanding, outcome sharing, that first affirmative insists on us is no longer under the memorandum of understanding, which is the basis, which now governs the two countries. Okay, to my next question. It is your position that a joint exploration and development is in the nature of a joint venture, correct?
Yes.
Are you aware yes? Are you aware that there is a legal definition of a joint venture, correct?
Yes, it is
So you're aware
contemplated
that
in
a
the
joint
case of
venture.
RBAC.
Thank you, Eunice. So you're aware that a joint venture is not the same as a joint exploration and development.
No,
correct?
I do not agree, Ms. Speaker.
So
They
you're
are the
saying that
same.
it is the same.
They have the same
I
elements.
see. Thank you.
as held
Thank you,
in the case
Eunice.
of RBAC.
As the first affirmative discussed, a joint exploration and development can be done in different ways. Do you agree?
Joint exploration and development
Yes.
in the context of this debate, Ms.
Yes.
Speaker,
Okay,
as
thank you,
provided by
Eunice.
their
Under the
agreements, is
Constitution,
through a
are you
joint
aware?
venture.
Thank you, Eunice. Under the Constitution, Article 12, Section 2, are you aware that it specifically provides that the President may enter into FTAAs for
Yes.
large-scale
Yes,
exploration?
precisely, Ms. Speaker, but that is not the subject of this
Eunice.
debate.
No, it is not. It is the subject of
Apparently,
this
our
debate.
President
Thank
is
you,
not
Eunice,
entering
for
into
your-
an
Thank you,
FTAA.
thank you,
He's
Eunice.
entering into a
Okay,
joint
under the
venture.
Constitution, the utilization of minerals, petroleum, and other mineral oils may be the President may be entered. President may enter according to this in FTAAs. Is that correct?
Yes, in FTAs,
thank
not
you,
joint
Eunice.
ventures.
Yes, but you limit your arguments into the other portions of this Constitution. You're giving a limited view to the audience, misleading this court as to the interpretation of this provision.
Okay, Jules, you've got 4 minutes to tell us why it would not be in the country's best interest to deem a joint exploration of the West Philippine Sea as unconstitutional.
Yes, good afternoon, ladies and gentlemen. Before I go to my speech, I would like to have a few rebuttals. First, it seems that the affirmative side is not updated with the times, as they are giving arguments based on the draft framework of the agreement between the Philippines and China. But as we know, there's already a memorandum of understanding between China and the Philippines. Second, the affirmative seems to be limiting a joint exploration and development as joint ventures. As the first affirmative has actually discussed, there are different ways in which the Philippines can explore and develop its resources. And finally, the affirmative believes that there is outcome sharing in the memorandum of understanding. But as we all know, and we can review it right now in our documents, that there is no such outcome sharing under the memorandum of understanding. Now on to my speech. Our proposition is beneficial for two reasons. First, we need a joint exploration and development because our energy resources are dwindling. And second, the investments that we have done in the past have gone nowhere because of several disruptions. On to our first point, Malampaya gas field is seen to plummet to a third of its current capacity by 2024 and is estimated to last only until 2029 depending on the demand in the coming years. The Malampaya gas field supplies 40% of the energy needs of Luzon. As it is expected to last only for 10 years, there is a pressing need for another energy source to replace the dwindling supply of Malampaya. Significantly, at least 10 years is required to pursue natural gas and petroleum energy projects. When Malampaya runs out of natural gas, the other viable option is to resort to importing fuel. However, it will definitely entail a higher cost which will be passed on to the poor consumers. But why must we resort to importing when we have resources just waiting to be extracted? Areas in the West Philippine Sea contain enormous deposits of natural gas. According to the United States Energy Information Administration, there are deposits in the West Philippine Sea which could hold at least 5.4 billion barrels of oil and 55.1 trillion cubic feet of natural gas. Data from the United States Geological Survey also show that there are significant deposits of hydrocarbons which are used in the production of fuel. These resources, as well as those of the untapped areas, are definitely sufficient to answer for our energy needs. On my second point, our previous investments have gone nowhere because of several disruptions. If we remember, back in 2003, Philippines already conducted opened the first public bidding for oil exploration over the West Philippine Sea, but there were no bids. Why so? For two reasons. First, China kept opposing it, and second, we could not guarantee profits over the exploration because the area is in dispute. It is to be noted that there have also been several instances where service contracts awarded over certain areas in the West Philippine Sea have not pushed through, also because of China's opposition and interference. Worthy to note is in 2015, Forum Energy was awarded a service contract over Rectobank, which was eventually ordered suspended because of the brewing dispute between the Philippines and China. In instances where the Philippines made efforts to explore and develop natural resources over the West Philippine Sea, China has made clear its opposition by several acts of lashing out. For example, when they were not included in the development of the Recto Bank, China started to conduct reclamation projects, built artificial islands, and actually installed military installments. These disruptive acts of China clearly made it difficult for the Philippines, to invest and exploit these resources. However, the move towards cooperation agreements and the inclusion of China is more to our benefit, as we will be able to fully enjoy and explore the resources that the West Philippine Sea holds. This is the key to solving our problem of dwindling energy resources, as well as diffusing China's aggression against us.
2 minutes for the cross-examination.
Ms. Speaker, are you aware of the case of RBAC versus sanitary wares?
Please enlighten me.
Okay, in this case, the court defines joint venture, and I quote, as community of interest, sharing of benefits and losses, and a mutual right of control.
Yes.
Now, Ms. Speaker, you mentioned earlier the Memorandum of Understanding on Cooperation,
Yes,
right?
I did.
And isn't not that, are you aware, of course you're aware of paragraph 2.
Yes, I'm aware.
And you're also aware of paragraph 2 of the draft framework.
Yes, I'm also aware.
And is it not that in both these documents, the underlying principle is on mutual benefit?
Why do you go to the underlying principle, Counsel? When
Because
it
that
clearly,
governs the framework.
Yes, sure, it governs.
Okay, Ms. Speaker,
but as
let
you
me
can see in the
proceed.
memorandum of understanding, there is no more
Okay, let me
outcome
proceed.
sharing.
Is it not that community of interest?
It is community of
Yes,
interest,
therefore,
but it is not
this
a joint venture.
exploration is a joint venture.
You are limiting the joint
Okay,
exploration
okay,
development
Ms.
to a
Speaker.
joint venture,
You
which is a technical
okay,
term.
Ms. Speaker, this is my time. You mentioned earlier that the Philippines has no capacity to explore this on their own. That's why we need.
Yes.
Okay. Are you aware of the records of the Constitutional Commission, specifically
Please
record
enlighten
number
me.
56? In this record, Ms. Speaker, the framers themselves acknowledge, Your Honors, that we are a state that is limited in in technical and scientific skill.
Yes, exactly. Clearly.
However, they chose specific provisions in our Constitution limiting the exploration, use, and
Yes,
utilization.
clearly, it limits the exploration,
Are you
use,
aware,
and
Ms.
utilization,
Speaker,
but under
that
the same
our
article that you are
Constitution is
using, it
unique
also
of all
provides
the
for
ASEAN
exceptions
countries.
when it comes to oil,
Okay,
petroleum,
Ms.
and
Speaker,
mineral oils.
let me proceed with my question. Is it not that in those records, the drafters themselves recognize that the direction of the Constitution should be towards
Yes,
a
clearly, they
self-reliant,
recognize
self-dependent economy?
self-reliant, self-dependent economy. But at this point in time, you
Okay,
are not
so
at that
you
ideal
acknowledge that indeed the
utopia
intent of
that
the
you want to do.
Constitution in
Yes, exactly. Of
prescribing
course, it is the intent of the
limits is in order
Constitution,
for
but
us
it
to
is
be
not
self-
feasible as of this moment.
But-
As you can see, we are not
Okay,
not
Ms. Speaker,
independent.
please let
We
me proceed
cannot.
with my. This is my time. Therefore, you acknowledge that the intent of the framers is despite
Yes, I
the
acknowledge,
fact
but it is not the current situation.
Let's now hear from the third affirmative speaker, Justine. You've got 4 minutes to tell us why it would be practicable to consider a joint exploration of the West Philippine Sea by claimant countries China and the Philippines as unconstitutional.
Your Honors, friends, good evening. Your Honors, there is a need to be technical in this case, as it is about our natural resources. The negative would want us to believe that joint exploration and development as a phrase only pertains to a mere description of a different regime, such as an FTAA. Your Honors, we refute this allegation as a matter of fact and as a matter of law. As a matter of fact, if we review the pertinent documents, the previous, subsequent, and contemporaneous acts of China and the Philippines since 2016 and 2017, under paragraph 5 and 3 of these joint statements, the words, and I quote, mutual benefit and outcome sharing exist. Your Honors, although the negative said that outcome sharing has been deleted from the Memorandum of Understanding currently in November 2018, the words mutual benefit has not been removed. Your Honors, again, we emphasize, as a matter of law, these states are aware of the legal consequences of their acts. If it is indeed the intention of China and the Philippines to enter into a service contract, they should have changed the words in the documents. and yet they have not. The consistency, Your Honors, is what we are debating upon in this debate. Which leads me to the issue of practicability. The negative's burden is to actually prove that the constitutionality of the proposition is actually correct. We refute this allegation for two reasons. First, Section 22, Article 12 of the 1987 Constitution provides, and I quote, that acts which circumvent or negate any of the provisions under this article shall be inimical to national interest and subject to criminal and civil sanctions as may be provided by law. It must be noted that Article 12 on national economy and patrimony is only second to Article 3 on the Bill of Rights, which provides an express provision on criminal and civil sanctions. As mentioned by Commissioner Noliedo and the records of the Constitutional Commission 384, the provisions of this article must be applied strictly against any act that would be improper in the use of our natural resources. Therefore, there is a need to dig into the technicalities of this debate. Your Honors, the negative would also want us to believe that if we allow China to proceed to disputed waters, and there will already be a resolution to these problems. Your Honors, it is not. The ruling of the arbitration committee is that it's no longer disputed. West Philippine Sea, as amended in under Administrative Order Number 29, published by President Aquino in 2012, belongs to the state. It falls under the sovereignty. Yes, Your Honor.
Mr. Speaker, if joint exploration is not the answer, then what is?
Your Honors, the answer is financial and technical assistance. What we are saying here is that there is actually no existing agreement yet. The purpose of this debate is to inform our public officials that we should enter only to a service contract with China and not a joint agreement. The political uproar, Your Excellencies, is already against the influence and illegal infiltration of China in our waters. As recently said, even reporters have been prevented to enter these waters. Lest we be misconstrued, we want to develop our resources for as long as they are exercised with utmost restraint and control. In a world where there is a foreboding Goliath with this China, the rule of law is our weapon and shield against its attacks. In the law, we must rest. Because if we do not follow the text of our Constitution, we will face catastrophic consequences. Your Honors, an FTAA is not a joint exploration and development. And thus, we end this debate with that note. Thank you, and may it please the Court.
2 minutes for the cross-examination.
Is it your contention in the affirmative that it is the very memorandum of understanding entered into by our foreign secretaries that is itself the joint agreement or the joint development?
No, it's not. What we say is that it reflects the intention of our public officials.
Thank you, Counsel.
Okay.
So therefore, you are aware that it is the contracts and the agreements that would result from this understanding between our countries that have to be examined and scrutinized for their constitutionality, yes?
Of course. However, why would we be debating about something when it has not existed yet?
Thank you, Counsel.
Okay.
And that's why, on your side, the allegation that a joint development is only a joint venture cannot stand because that is speculative on your side.
No,
is
it's
that
not,
the
because
case?
it has to be strictly construed as provided by the records of the Constitutional Commission. Words such as joint
Sorry, Counsel.
are not exactly service contracts, Ms.
Counsel.
Speaker. Okay.
To clarify.
Okay.
So you're therefore saying that the only thing that you're against is our states entering into joint ventures, and that is the only type of agreement that you would find to be unconstitutional.
Precisely, because the documents show the intention is to enter into joint ventures. And we're trying to prevent that, Your Honors.
Let us, in terms of the Memorandum of Understanding,
Okay.
you understand that in paragraph 3B, there is not yet a particular area. The maritime areas are yet to be determined by the Joint Steering Committee.
Again, that is the issue, because Administrative Order Number 29 by
Sir,
President Aquino in 2012
Counsel.
already defined these territories.
Counsel, there is no yet defined area in which there would be cooperation agreements. Cooperation
Again, because
agreements
the
and
joint agreement did not construe our Administrative Order Number
Counsel.
29, which defines what West
Counsel.
Philippine Sea is, Ms. Speaker. If we rely highly on
the
that,
words the West Philippine Sea do not appear in the Memorandum of
well, it
Understanding.
appears
Is that
in
correct?
AO 29, it defines all our territories which are no longer disputed. And that is actually what is in the proposition.
Bea, you have 4 minutes to tell us why it would not be practicable to deem the proposed joint exploration of the West Philippine Sea as unconstitutional.
On November 20th, when there was the signing of the Memorandum of Understanding between our governments as represented by our foreign secretaries, it was clear that the landscape changed when it came to discussing China and the Philippines cooperating within the maritime area. And this is so because the draft framework that they have been basing a lot of their arguments from only embodies what China wanted to demand from us, whereas the Memorandum of Agreement is what stands to show what was the real understanding of the parties. That's the reason why things like outcome sharing no longer appear. This is the reason completely why there is a paragraph 4, the relevant position of the states. Let us reiterate, which our first speaker had already spoken of, and that they did not acknowledge, the idea that there are no rights and obligations created under international or domestic law by this memorandum, and that any of the acts of the Joint Steering Committee, any of the cooperation arrangements that would arise from them do not prejudice the respective legal positions of these states. This was clearly entered into and made a part of the Memorandum of Understanding precisely because there are no territorial claims that are being given up by our state. We think on their side, the reason why the affirmative has been very clear in terms of their debate only being limited to joint ventures is because they think that this is a debate merely about the territorial dispute. That is not the case. This is a debate about the utilization of our natural resources. And they say that the only way that the Philippines will do it with China is to enter into these joint ventures. We don't think that that's clear at all. Precisely because when you look at paragraph 3B, which does discuss the responsibilities of the Joint Steering Committee that was formed, which is in fact to create those cooperation arrangements, which is to identify the working areas. We think that that's clear that many different regimes can govern when it comes to these different working areas, which means that the legal and constitutional agreements that are enumerated under Article 12, Section 2's first paragraph as well as fourth paragraph can all enter into it because we have enterprises that are representing us on both sides in terms of that Joint Steering Committee, which means that it's not necessarily the case that it's always going to be the CNOOC. Yes, Madam.
Ms. Speaker, what then is the purpose of the joint exploration if not for the benefit of both or the mutual benefit of both countries?
We think, Madam, it's clear that when it comes to just returns that are identified under PD 87, which is the governing law on oil and gas development, those will be built into the service contracts, and those are the considerations that would be provided to the Chinese entities who we would be cooperating with. And we think when that is the case, and the fact that we do have laws that do govern and laws that will be written into the agreements that we may enter, whether or not they are the FTAAs, we think then precisely that it's clear that we're not giving up the beneficial ownership of these areas in the maritime resources. Particularly, they say that the FTAA is all that they would allow, but we're still not sure, Madam, which actors would be participating. But yes, sir.
Are you saying that the joint exploration and development is actually a technical and financial assistance?
We are saying that an FTAA could be the result of them because we think that the Memorandum of Agreement, of Understanding rather, provides the roadmap, and it will be, and what results can be FTAAs, can be other legal and constitutional agreements.
Okay, 2 minutes now for the cross-examination.
Good evening, Ms. Speaker. Ms. Speaker, you mentioned paragraph 4 of the MOU, right?
Yes.
And yes, okay. So you also noticed that in paragraph 2, the words mutual benefit still exist.
Yes.
Okay. And you also noticed that the purpose of that MOU is actually to create a joint steering committee, correct?
Yes.
Okay. So therefore, we cannot actually rely only on the MOU, right?
Yes, because
okay,
it's what
I'll
results
take
that
as a
we're
yes.
going to be judging,
so
right?
if we take intention, Ms. Speaker, don't you believe that under the principle of international law, subsequent contemporaneous and previous conducts of state must be taken into consideration, correct?
But circumstances have change for China.
Yes or no,
we
Ms.
think they
Speaker?
have to save
Yes or no?
face in terms of how they're going to enter into
Precisely.
agreements
So therefore, you agree.
post-arbitration.
Therefore, you concede that because there were intentions by China to enter into joint steering committees, therefore the intention of the states is actually to enter into joint venture. You have not
The
rebutted.
reason why that they're entering into a joint arrangement with this is precisely because they are respecting our rights or our claims
Let me proceed
in
with
these
that
areas or
agreement.
in our interests.
So you also mentioned that these waters are still disputed, correct? And there will still identify these working areas, correct?
Yes, because there's a reservation
Now, Ms.
within
Speaker,
this very agreement
are
that
you aware
our
of
legal
Article
positions
77,
remain the
paragraph
same.
2 of the UNCLOS?
Yes.
And under this, the coastal state has the sovereign right over our shores, or rather our continental shelf, including that into the exclusive economic zone, which is 200 nautical miles.
But even
Yes or
within
no,
our
Ms.
own
Speaker? Yes or
even
no?
within our own
Which is
constitution, we still
incorporated in
allow
our constitution.
agreements to be entered into by the
Precisely.
states with foreign
However,
actors.
therefore, it is no longer disputed because these
Yes.
waters are already ours. There's already no longer
we
need
agree that the waters are ours.
Also, so you concede that we no longer need to negotiate
But
with
your
China
understanding of a
as to
joint
how they
venture
will
is
control these
extremely limited
waters.
because we think that when you have
Okay.
actors from both sides, it would still
Let me proceed to
constitute
my next
joint
question.
exploration
So you
and
agree with me
development.
that when you say mutual, there is also a share of control.
No, we don't think that that's the case at all.
That is
because
very myopic,
there can
especially
be
when you
different
have to
types of
apply
actors
these words
and different types
strictly,
of agreements
especially
that are
natural
born from
resources.
this memorandum.
No further questions.
Let's now hear what our judges have to say about our debaters. Attorney Liu, how did the affirmative side do?
The affirmative side was able to set the tone and the direction of this debate and give the adequate basis for their arguments.
And Attorney Cases, how did the negative side do?
The negative side presented more or less on the practicality and economic benefits of the joint exploration, and it was limited to such only.
And now let's hear from our chief adjudicator, Judge Maria Teresa Camano. Your Honor, who did the judges pick for Best Speaker?
For the best speaker, we have the first speaker of the affirmative side, Ken Aquino.
And the school that won tonight's debate.
This is very exciting. And the winner for tonight's debate is the affirmative side, University of San Carlos. Congratulations.
A big congratulations to the University of San Carlos for winning the final slot in the semifinals. I'm Mike Oreta. Thank you for watching.